I'm Tom Thorson, owner of Thorson Financial Estate Management Incorporated here, where we are located on Standiford Avenue in Modesto, California, where we have been located for over 25 years now. Now at Thorson Financial Estate Management Incorporated, we specialize in working with retirees and pre-retirees where we are devoted to providing solutions for your financial life. Now in this video, I will be talking about wills versus trusts, a very important topic that comes up often in my interactions with clients. I'm often asked what the difference is between having a will or a trust. And does it make a difference? Well, first let's discuss similarities. Both the will and a trust provide instructions on how you want property, such as real estate and bank accounts, brokerage accounts, to be distributed at your death. As an example, at your death, you may want all assets to go to your spouse 100%. Then after both spouses pass away, all goes to kids or grandchildren in equal amounts right away or after a certain age. Of course, you can choose. So that's a will and a trust work the same on that level. Now, what are the differences? The biggest difference is that a will must be carried out by a probate court where they will process instructions you specified in the will. Now, there are fees associated with a probate along with time it takes to complete the process. A primary job for probate is to change title on property and accounts from the deceased to the living beneficiaries. This is all accomplished mostly by people you may not know. Now, a trust, on the other hand, is able to avoid the court probate process and distribute assets privately, typically among family members or people you trust to handle this process. Now, the trust is able to avoid probate because assets can be owned within the trust itself as an entity. Essentially, the trust is created, and then we help you transfer all property to the trust, and you become the trustee with complete control of all assets. You will choose a successor trustee to take over at your death or incapacity. At your death, the successor trustee, often a son or daughter of your choosing, takes over as fiduciary and manager of the trust. The successor trustee is responsible to distribute assets to the beneficiaries. Successor trustees are often beneficiaries themselves. The primary technique that makes the trust work, and this is a common question, what really makes the trust operate? Well, the primary way it makes it that the trust works is and avoid probate is the retitling of assets from the individual to the trust before death occurs. Now, when death occurs, retitling is not necessary because the trust is owner and doesn't die. Much of probate court's role is to transfer assets from the deceased to the living. Now at Thorson Financial Estate Management Incorporated, all our legal documents are created and prepared through a California bar attorney. Thorson Financial provides all client required information to the attorney's office to begin the legal document preparation and process. Thorson Financial Incorporated does not give legal advice. However, with the attorney's assistance, we provide meaningful information and guidance. Now, estate planning can be complex. No matter the age, with so much at stake, it's crucial to have things set up appropriately to protect against the loss of money, time stuck in probate, and most important, family heartaches. We're happy to work with you to secure and make the most of your legacy. Please send a message to us at the bottom of this page for additional information or call our office at 209-522-0250. We can help. Until next time, I wish you well.